5 seconds. We have two sets of writ petitions before us which involve identical points except for one material difference which we will mention later. Writ petitions for 2282 for 230 of 1978 are filed by three judicial officers of the state of Haryana who are promotees, that is to say, who were promoted to the superior judicial service of the state from the Haryana Civil Service Judicial Branch. Respondents 1 and 2 to those writ petitions are the state of Haryana and the High Court of Punjab and Haryana respectively. Respondent 3 Sri N.S. Rao is a direct recruit having been appointed from the bar to the Haryana Superior Judicial Service. Writ petition 266 of 1979 is filed by 22 promotees, that is to say, those who were promoted to the Punjab Superior Judicial Service from the Punjab Civil Service Judicial Branch. Respondents 1 and 2 to that petition are the State of Punjab and the High Court of Punjab and Haryana respectively. Respondents 3 to 11 were appointed directly from the bar to the Punjab Superior Judicial Service. Ever since November 1, 1966, when the state of Haryana was formed, there has been a common high court for the states of Punjab and Haryana called the High Court of Punjab and Haryana. Two separate high courts were not created for these two states, probably because of considerations of viability in regard to one of the states and the need to foster a spirit of national integration. But the fact of there being two separate governors for the two states with independent powers under the proviso to Article 309 of the Constitution has made the task of the High Court difficult and unenviable. The Chief Justice and judges of the Common High Court of the two states are faced with the predicament of applying one set or service rules to members of the superior judicial service of one state and a totally different and to a large extent opposite set of rules to those of the other state. As the matter stands today, and we mean what we say because there is no knowing when one or the other state will amend the rules and with what degree of retroactivity under the Haryana First Amendment rules 1977 cadre post means a permanent post in the service. Temporary posts are not cadre posts in Haryana. In Punjab, cadre post means both permanent and temporary posts in the superior judiciary. The definition of cadre post has a significant bearing on the fortunes and future of judicial officers. In Punjab, prior to the amendment made to the 1963 rules on December 31, 1976, promotees alone used to be appointed through on an officiating basis to temporary posts in the superior judicial service. Direct recruits were not appointed to temporary posts because temporary posts were outside the cadre and C. Direct recruits were appointed to cadre posts only, in which they were entitled to be confirmed on the completion of the probationary period. After the amendment, applications were invited for direct recruitment to temporary posts also, with the result that promotees lost the opportunity of being appointed to those posts, though on an officiating basis. Respondents 9 to 11 in the Punjab writ petition were appointed directly in July 1977 to temporary posts of additional district and session judges.